So October 28th, the Copyright Office officially released the Section 1201 exemptions to prohibitions against the circumvention of technological protection measures protecting copyrighted works, and it's being reported that this is going to help the right to repair movement. Let's take a look at what's going on here. First, the code. 17 U.S.C. 1201 is a section of the Digital Millennium Copyright Act that prevents the circumvention of copyright protection systems. No person shall circumvent a technological measure that effectively controls access to a work protected under this title. But during each succeeding 3-year period, the law was enacted back in 1996, the Librarian of Congress, with the recommendation of the Register of Copyrights, shall make a determination of whether persons who are users of a copyrighted work are adversely affected by the prohibition above in their ability to make non-infringing uses under this title of a particular class of copyrighted works. And that's what we're going to look at today. This is the Federal Register. This is part of administrative law. The Register of Copyrights, the Copyright Office, the USPTO, these are all agencies of the federal government. They're usually agencies under either the legislative branch or the executive branch, usually the executive branch, because the executive branch is charged with executing the law made by the legislative branch. So when an agency is delegated authority, it's only allowed to act within its discretion. Well, when it exercises its discretion and makes a new rule, regulation, law, it sort of has the effect of a law. Well, there has to be some kind of due process. And the way that's embodied in administrative law is by making these rules, publicizing them, getting commentary from the public, and then implementing the rule after some period of time, like 90 days or something like that. So this is the final rule, and that's just why it's in the format that it's in. So this is the Library of Congress Copyright Office exemption to the prohibitions on the circumvention of copyright protection systems. In this final rule, the Librarian of Congress adopts exemptions to the DMCA that prohibits circumvention of technological measures that control access to copyrighted works. After careful consideration, the librarian adopts final regulations based upon the Register's recommendation. Background. Congress enacted the DMCA in 1998. Sorry, I said 1996, to implement certain provisions of the WIPO copyright and WIPO performance and phonogram treaties. In enacting 17 U.S.C. 1201, Congress observed that technological protection measures can support new ways of disseminating copyrighted materials to users and safeguard the availability of legitimate uses of those materials by individuals. And you can see the effect of having that. We now have online streaming. Even new releases of movies to the theaters are also being simultaneously done on Disney Plus or HBO Max or whatever, because they're comfortable with the digital rights management that they can implement, the technological protection measures. Under the statute, to circumvent a technological measure means to descramble a scrambled work, to decrypt an encrypted work, or otherwise to avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. A technological measure that effectively controls access to a work is one that, in the ordinary course of its operation, requires the application of information or a process or a treatment with the authority of the copyright owner to gain access to the work. So the arguments like CSS doesn't effectively control access to a video on a DVD because we can crack that pretty easily because that encryption key has been released to the public, that's not really a valid legal argument. It's certainly a valid technological argument. Yeah, it's really easy to do. You can buy programs and do it pretty easily. But you don't have the authority of the copyright owner, so therefore, legally speaking, it does still effectively control access under the law. Section 1201 also includes what Congress characterized as a fail-safe mechanism, which requires the Librarian of Congress to exempt any class from the prohibition for a 3-year period if she has determined that non-infringing uses by persons who are users of copyrighted works in that class are adversely affected, as we read before. So these exemptions will be recommended and then adopted, and they will apply. If you want to read about the rulemaking standards, you can read about that here, and they give some more history of the 8th triennial proceeding. So this is the 8th time in, I guess, 24 years that we are here. The Register will only recommend granting an exemption when the preponderance of the evidence in the record shows that the conditions for granting an exemption have been met. To establish the need for an exemption, proponents must show that uses affected by the prohibition on circumvention are likely to be non-infringing, that as a result of a technological measure controlling access, the prohibition is causing or will cause an adverse impact on those uses. The office initiates the rulemaking proceeding through a notice of inquiry. The office received 26 petitions for new exemptions, including 13 comments seeking to expand certain current exemptions. So then here are the final regulations. So once again, we are exempting uses from the prohibition against circumvention, which means these uses are allowed to circumvent. Once the law is implemented, they are allowed to circumvent technological protection measures. And it says, 1. Motion pictures, including television shows and videos, where the motion picture is lawfully made and acquired on a DVD protected by the Content Scrambling System, CSS, or a Blu-ray disc protected by the Advanced Access Content System, AACS, or via digital transmission protected by a technological measure, and the person engaging in circumvention reasonably believes that the non-circumventing alternatives are unable to produce the required level of high-quality content, or the circumvention is undertaken using screen capture technology that appears to be offered to the public as enabling the reproduction of motion pictures after the content has been lawfully acquired and decrypted, where circumvention is undertaken solely in order to make use of short portions of the motion pictures for the purpose of criticism or comment, for use in documentary filmmaking or other films where the motion picture clip is used in parody or for its biographical or historically significant nature, for use in non-commercial videos, including videos produced for a paid commission if the commissioning entity's use is non-commercial, or for use in non-fiction multimedia ebooks, for educational purposes by college or university faculty and students, or kindergarten through 12th grade educators and students, or employees acting at the direction of said faculty, for the purpose of criticism, comment, teaching, or scholarship. So that's all still part of the one thing. You can't decode CSS or AACS if you are doing it for some other purpose. But if you are doing it for documentary filmmaking or biographical or historical purposes, or for nonfiction multimedia ebooks, or for educational purposes at a college or university, then you're under this law. So if you're not doing that, if it's just for at-home use or whatever, you don't fall under this exemption. And if you got sued, you can't really use this. Also by faculty of an accredited nonprofit educational institution offering massive open online courses. So basically educational institutions. By educators and participants in nonprofit digital and media literacy programs offered by libraries, museums, and other nonprofit entities with educational missions. 2. Motion pictures, where circumvention is undertaken by a disability service, office, or other unit of an educational institution, kindergarten through 12th grade, college, university, etc., for the provision of accessibility services for the purpose of adding captions and/or audio descriptions. The educational institution has to have a reasonable belief that the motion picture will be used for a specific future activity of the institution, so not just providing an accessible copy. The accessible versions are provided to students and educators and stored by the educational institution in a manner intended to prevent unauthorized further distribution of the work. It can be used for audio descriptions, accessible versions, and that's it. Motion pictures again, where such activity is carried out without any purpose or direct or indirect commercial advantage because the DVD or Blu-ray disc is damaged or deteriorating, the eligible institution, after reasonable effort, has determined that an unused and undamaged replacement copy cannot be obtained at a fair price. No streaming service, download service, or on-demand cable. So if it's like out of print and out of distribution, the preservation or archived copy is not distributed outside of eligible library archives or museums. So only for library archives or museums in that case. And it must have already been lawfully acquired or licensed. Again, motion pictures, where the circumvention is undertaken by a researcher affiliated with a nonprofit institution of higher education or by a student solely to deploy text and data mining techniques on a corpus of motion pictures for the purpose of scholarly research and teaching. The copy must be lawfully acquired and owned or licensed. The person undertaking the circumvention views or listens to the contents solely for the purpose of verification of the research findings. The institution uses effective security measures to prevent further dissemination. And then it goes through a bunch of requirements for what is a higher education institution. 5. Literary works, where the circumvention is undertaken by a researcher. It looks very similar to what we just talked about with motion pictures. 6. Literary works, or previously published musical works. When a copy or phonorecord of such work is lawfully obtained in order to enable the read aloud functionality or other screen readers or assistive technologies on a lawfully obtained copy, and does not include a sound recording of a performance of the musical work unless and only to the extent the recording is included as part of an audiobook or ebook. So it's to enable accessibility or screen reading functions. Literary works consisting of compilations of data generated by medical devices or by their personal corresponding monitoring systems, where such circumvention is undertaken by or on behalf of a patient for the sole purpose of lawfully accessing data generated by the patient's own medical device or monitoring system. This is not a safe harbor from HIPAA, an oft misunderstood law. 8. Computer programs that enable wireless devices to connect to a wireless telecommunications network when circumvention is undertaken solely in order to connect to a wireless telecommunications network, and such connection is authorized by the operator of the network. That seems like unlocking phones to connect to a different provider's network as long as you're authorized by the new provider. That's pretty cool, but the unlocking phone things has been there before. 9. Computer programs that enable smartphones and portable all-purpose mobile computing devices to execute lawfully obtained software applications, where circumvention is accomplished for the sole purpose of enabling interoperability of such applications with the computer programs on the smartphone or device, or to permit removal of software from the smartphone or device. So you can remove software from your device. If you have to circumvent a technological protection measure, you're exempted from being liable under the DMCA. 10. Computer programs that enable smart televisions to execute lawfully obtained software applications, where the circumvention is accomplished for the sole purpose of enabling interoperability of programs and is not accomplished for the purpose of gaining unauthorized access to the copyrighted works. So you can put applications on your smart television. 11. Computer programs that enable voice assistant devices to execute lawfully obtained software applications, where circumvention is accomplished for the sole purpose of enabling interoperability of programs or to permit removal of software from the device, and is not for obtaining unauthorized access. These are devices that are designed to take voice input from a user, usually installed in a home or office. 12. Computer programs that enable routers and dedicated network devices to execute lawfully obtained software applications, where circumvention is accomplished for the sole purpose of enabling interoperability of such applications with computer programs on the router or dedicated network device, and is not for gaining unauthorized access. This includes switches, hubs, bridges, gateways, modems, repeaters, and access points. I'm guessing it also means routers, and excludes devices that are not lawfully owned. So if you own your network device, you can put your own software on it. This makes me think of like OpenWRT and the old oh, I forget what brand it was, the blue and black routers that I used to put OpenWRT on. Linksys, it was Linksys. 13. Computer programs that are contained in and control the functioning of lawfully acquired motorized land vehicle or marine vessels, such as personal automobiles, boats, commercial vehicles or vessels. I'm thinking of John Deere. Or mechanized agricultural vehicle or vessels, except for programs accessed through a separate subscription service, when circumvention is necessary to allow the diagnosis, repair, lawful modification of a vehicle or vessel function, where such circumvention is not accomplished for the purpose of gaining unauthorized access to copyrighted works. This is not an exemption or safe harbor from or a defense to liability under other applicable laws, including without limitation regulations promulgated by the Department of Transportation or the EPA. So that's a controversial one. If you have a subscription service with John Deere, you probably can't use that exemption. But if you own your tractor or own your vehicle or own your boat or vessel or whatever, and you want to get access to your software for the purposes of diagnosis, repair, or lawful modification, then it sounds like you've got permission to do so. 14. Computer programs that are contained in or controlling the functioning of a lawfully acquired device that is primarily designed for use by consumers when circumvention is a necessary step to allow the diagnosis, maintenance, or repair of such device and is not for the purposes of gaining unauthorized access to copyright works. The maintenance of the device is the servicing of the device in order to make it work in accordance with its original specifications and any changes to those specifications authorized for that device. The repair of the device is the restoring of the device to the state of working in accordance with its original specifications and any changes authorized for that device. For video game consoles only, repair is limited to repair or replacement of a console's optical drive and requires restoring any technological protection measures that were circumvented or disabled. So you can repair your devices under this. If Apple has some kind of technological protection measure that prevents you from changing the fingerprint reader or camera module or something, it appears you're now going to be authorized to repair that. So Louis Rossmann, eat your heart out. It seems like there's some kind of right to repair built into the new copyright exemptions. And Apple doesn't seem to have the right to sue and win if you repair your MacBook and repair your iPhone and have to circumvent some kind of technological measure to make it work. I don't know how easy that's going to be to do, but it shouldn't get you a copyright lawsuit, at least not successfully now. However, video game console repairs are still going to be limited to just the optical drive, and if you had to disable any technological protection measures to get the drive installed or authorized or something, you then also have to restore that measure. So you can't just replace the optical drive in a way that enables the playing of unauthorized discs or games or something, is what it seems to be saying. 15. Computer programs that are contained in or control the functioning of a lawfully acquired medical device when circumvention is necessary to allow the diagnosis, maintenance, or repair of such a device. So it seems like you can repair your medical devices as well. 16. Computer programs on a computer device which operate on a computer system, or computer network with the authorization of an owner or operator for the purpose of good faith security research, which means accessing a computer program solely for the purposes of good faith testing, investigation, or correction of a security flaw or vulnerability. So you won't be liable for breaching a technological protection measure where you were doing security research in an authorized fashion. And there's some more qualifications here. Security research may nevertheless incur liability under other applicable laws, including the Computer Fraud and Abuse Act, and eligibility for the copyright exemption is not a safe harbor from other laws. 17. video games in the form of computer programs embodied in physical or downloadable formats that have been lawfully acquired as complete games when the copyright owner or authorized representative has ceased to provide access to an external computer server necessary to facilitate an authentication process to enable gameplay solely for the purpose of permitting access to the video game to allow copying and modification of the computer program to restore access to the game for personal, local gameplay on a personal computer or video game console, or permitting access to a video game to allow copying and modification when necessary to allow preservation of the game in a playable form by an eligible library, archive, or museum where such activities are carried out without any purpose of commercial advantage and are not distributed or made available outside of the library, archive, or museum. So you can play games at the library, archive, or museum as part of their services. Two, video games in the form of computer programs embodied in physical or download formats that do not require access to an external computer server for gameplay that are no longer reasonably available on the commercial marketplace solely for the purpose of preservation by an eligible library, archive, or museum. And 3, computer programs used to operate video game consoles solely to the extent necessary for an eligible library, archive, or museum to engage in preservation activities. Complete games need to be complete in themselves and not have to access media on some outside server. And then they go into some definitions of what it means to cease to provide access or local gameplay. But it seems to mean that the game is no longer available for at least 6 months. Server support has not been restored. Local gameplay is defined, and eligible libraries, museums are eligible under these circumstances here. 18, computer programs, except video games, that are no longer reasonably available in the commercial marketplace. I had this happen once. I bought some modern software. I believe it was LexisNexis. They made bankruptcy filing software for attorneys who file bankruptcies for their clients, and it required Adobe Acrobat Professional version 6, which was no longer available at the time. And one of the only times that I have committed any kind of copyright infringement in my legal career was that time that I had to go on the Pirate Bay and download a cracked copy of Adobe Acrobat Professional 6 or something like that in order to make this LexisNexis software work, which I thought was a huge oversight on Lexis's part. I had even contacted Adobe. I have an Adobe subscription. I have the Creative Cloud subscription, and you just can't access software that far back, or at least you couldn't at that time, back in like 2012 or something like that. So computer programs, not video games, solely for the purpose of lawful preservation of a program. Oh, in this case, it says by an eligible library, archive, or museum. So it doesn't even address my use case from 10 years ago. 19, computer programs that operate 3D printers that employ technological measures to limit use of material when circumvention is accomplished solely for the purpose of using alternative material and not for the purposes of accessing any design software files or data. 20, computer programs solely for the purpose of investigating a potential infringement of free and open source computer programs where the circumvention is undertaken on a lawfully acquired device or machine other than a video game console, where the circumvention is performed by or at the direction of a party that has a good faith reasonable belief in the need for the investigation and has standing to bring a breach of license or copyright infringement claim, where such circumvention does not violate other applicable law, where the copy of the computer program is not used or maintained in a manner that facilitates infringement. And finally, 21, video games in the form of computer programs embodied in lawfully acquired physical or downloadable formats and operated on a general purpose computer where circumvention is undertaken solely for the purpose of allowing an individual with a physical disability to use software or hardware inputs other than a standard keyboard or mouse. So if you have to crack the software to enable your assistive device for your physical disability, that also sounds like it's not a copyright violation. So those are some great things, especially for museums and libraries and other archival institutions. But it seems like consumers get the right to access their medical data on their medical devices. The right to repair movement gets a win in the sense that they now have the right to circumvent copyright protection measures to repair devices to their original specifications or their updated specifications from the manufacturer. And the optical drives of video game consoles can be replaced as well. I don't know exactly how that's going to be done by the repair services, but if they have to do it, they're not going to be in violation of any kind of copyright. I would still recommend that you don't take my summary here as legal advice and go make dollars worth of decisions based on a YouTuber lawyer's general opinion. So definitely, this is not legal advice. This is not individualized legal advice. Go get advice from your attorney on how this applies to your organization before you just go and use it, lest you find yourself on the receiving end of a copyright lawsuit. So that disclaimer aside, I think these are great exemptions. It's progress. It's not everything that everyone on the consumer end of things would want. You can't repair your video game console beyond the optical drive, which is kind of weird. You should be able to, but I didn't make the law. If you are new to this process, now you know. The next one's going to be in 3 years. Look at the copyright.gov website for the next notice of proposed rulemaking here. And this one was October 15th, 2020, so expect it October 15th, 2023 or thereabouts. And submit a proposal, submit a comment, submit a proposal on what you'd like to see if you missed it this time. Let me know what you think in the comments below. Were you satisfied with these? Do you think too many of these exemptions only apply to archival institutions or museums or libraries, and you'd like to see permission for users to archive their DVDs and things like that? Let me know what you think. Thanks for watching. Special thanks to our top supporters in November: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Join me for our weekly production live stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern U.S. time. I hope everyone has a great week. I love you all. Bye.